Okay, ladies and gentlemen, we'll go ahead and get ready and get moving on the juvenile justice meeting. I'll hereby call this meeting to order. And the first bill and the second bill that we're going to be hearing, I'm actually carrying. So I am going to switch chairs with our Vice Chair Camp and let her preside over the meeting. Vice Chair Camp.
Do you want to start with the first on the agenda? Okay. Do you need your folder? There you are. Thank you. At this time, we call upon Chairman Mandy Ballinger. She's going to be presenting to us HB 274.
Thank you, Madam Chair. I appreciate that. We are working from LC 480573S. A few years ago, whenever we did our accountability courts, it was reasoned that it would be extra work on our superior and state court judges who were adjudicating alternative sentencing courts, so we gave them a $6,000 supplement for that. And unfortunately, we left our juvenile court judges out. This bill has gotten the green light from, it actually is appropriated. The funds are in appropriations, and it is good with appropes, and everyone is happy with it. We were concerned that we would make the juvenile, if we did a direct pay to the juvenile court judges, that they might become employees, but that has all been worked out. So I'll be more than, it just allows for the supplement for our juvenile court judges, and I'll be more than happy to take questions.
Thank you, Chairman Ballinger. Do we have any questions from our committee at this time? All right, thank you. It appears we don't have any. Do we have any questions from any concerned members present? All right. Do we have a motion?
I move to pass.
Thank you. Do we have a second? Thank you. All in favor?
Aye.
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 Okay. All right. For our members on Zoom?
Aye.
Aye.
All right. In favor of do pass?
Aye.
All right. Thank you. All right. It appears ayes have it. Thank you very much, Chairman Ballinger. If you could go ahead with us and present HB 1234.
1234 is a very simple bill, and it allows for an attorney for any child receiving extended care youth services from DFACS shall have an attorney for that dependent child. It just allows for them to have legal representation. This was brought to me by the Department of Family and Children's Services. Their representative here is here. Matt, Mr. Wasatowski, if you'll stand up. If you have any questions, both myself and Mr. Wasatowski can answer those.
All right. Thank you very much, Chairman Ballinger. Does anyone in the committee have any questions regarding this bill? Seeing none, this would be the time for someone to make a motion.
Move to pass.
All right. Do I have a second? Thank you so much. All right. All in favor, say aye.
Aye.
Aye. Any opposed? All right. Thank you so much. Motion passes. All right. This time, I'll turn it back over to Chairman Ballinger.
Thank you.
Hopefully some good news.
I do apologize. Representative Neal, do you have a question?
Say it one more time. I'm sorry, I was trying to make the motion.
Oh, okay. All right. Need to turn my mic on. At this time, it being the longest bill, and I think we actually have somebody on Zoom waiting to testify on it, we will call House Bill. What is your House Bill? It was just dropped today. Representative Wiedauer, will you stand up? You can either stand at the podium, you can have a seat at one of the chairs. Anywhere there's a mic will be fine. Yep. Okay, because this is kind of a little bit unusual for us to give a hearing at such a late time, I want you to introduce yourself, introduce the bill, including the LC number, because I understand that there is a sub, and tell us a little bit about your bill.
Thank you, Madam Chair. So, Representative Wiedauer bringing you House Bill 1508, LC 490920. If you give me a nod when okay, I want to make sure you have that in front of you.
I do apologize to those that are on Zoom. You will not be able to, you'll be able to follow along with Representative Wiedauer, but we will not be able to provide you with copies of the bill as it just got filed. When did you file this bill, Representative Wiedauer?
It was last week.
Last week?
Yes,
okay. I think it's now a second reader. It's not even available online yet. So I do apologize to that for our online folks, but for those that are here, you should see the bill in your folders. And again, that's LC 490920. Representative Wiedauer?
Thank you. We've dropped this bill before, similar versions of it. This is dealing with aggravated circumstances in child placement. Bottom line, as we move through it, starting in section 2, I apologize, I didn't know I was going first. Give me 2 seconds to get my notes together. Starting in section 2, the bill adds a child born addicted to alcohol or illegal drugs and a parent history of chronic unrehabilitated substance abuse. And the court finds the substance abuse is likely to continue and not likely to be remedied. So this is dealing with children that are born addicted to drugs, and again, a history of this with that particular parent. Section 2 also defines chronic abuse and neglect. This aggravated circumstance is already in Georgia law, but it's not defined. This bill defines it. Moving on to section 3. This gets into when reunification efforts are not required. Line 84, it removes the shall and gives the court more discretion on the decision to move a child's case to permanency quicker. Lines 91 through 107. This cleans up some Georgia existing law. It adds that reunification efforts are not required by the court if a parent has had parental rights terminated before and the circumstances leading to the termination still exist. In other words, if we've already offered a reunification efforts to this parent before on the same issue, and we're seeing the history be repeated. Section 3 again, it also requires defects to report in writing to all parties if they believe an aggravated circumstance exists in a child's case. If this happens, a hearing in 30 days. And if there is clear and convincing evidence that an aggravated circumstance exists, the presumption is that the case should proceed to termination so the child can have permanency. Parents can overcome this presumption in a court hearing by either showing that their conduct was an aberration or showing that the parent has been rehabilitated. Oh, sorry, you're looking right there. Yes, sorry. Thanks, Wes. Representative Cantrell. Going to section 4. Excuse me, go to section 5. If the court moves a child case to permanency, requires a TPR petition in 30 days unless compelling reason by defects, which will be in the written report suggested before. Line 253, if DFACS doesn't file a petition to TPR, this doesn't bar another person from filing. Section 6, this allows the court to consider the harm done to a child in termination proceedings. If you'll look at that a little deeper, lines 265 through 274, it defines in some of those aspects in which the court can consider attachment. That's the quick run-through of the technicalities of the bill. I do also have Jennifer Shimpo here with me, who I know would like to speak to the bill as well when that's appropriate.
Okay, all right. I'm sorry. Will you introduce yourself and committee members online? Our policy analyst, Brian Hines, has emailed everybody a copy of this bill. And I think we have some extra copies of some of the folks in the audience would like a copy. Andy, is that correct? Just see Andy over here if you would like a copy of the bill. So, Madam, if you would just introduce yourself to the committee and your connection to the bill.
Sure. Hi, my name is Jennifer Shimpo, and I work as the Georgia Liaison for Generation Justice. And I'm also an advocate on the board of the Adoption and Foster Parent Association of Georgia. And my husband and I have a history of fostering. We fostered for 7 years and then had the pleasure of adopting 2 of our 5 children out of foster care who had been in our care for almost 3 years. And this bill is especially important to me for several reasons, but the 2 children that we adopted, this touched their lives personally. They were number 3 and number 4 of a family who had chronic unrehabilitated drug abuse. And the previous 2 children that were in the care of these biological parents had already been severed, and we were trying again to reunify children who were born addicted to meth, which is the number 1 drug right now in Georgia. That is the choice drug in our state. And the history of that is, if you look into the statistics, the average person to overcome an addiction for meth is 8 years. So we're not talking about children who are involved with parents who have, they're working a plan for substance abuse. We're talking about parents who have unrehabilitated substance abuse in this case. Those were our children. I've walked alongside of also many other foster parents who have similar situations like this, where children are lingering in care past 2 years while we're trying as a state to continue rehabilitation for parents who are not making progress and who have basically said, I don't want to work a case plan. So this would really help push those children towards permanent situations quicker, and it would address this in aggravated circumstances, which, as you know, aggravated circumstances are the most egregious crimes against children. They're crimes that we know parents are not coming back from. They're going to not reach their reunification goals in these situations. And it's the same for chronic, unrehabilitated drug abuse for children born in these types of situations. This bill is lengthy, but it has great things for the best interest of children in it. It brings us into federal compliance, like Representative Wiedau mentioned, and really the goal is to cut down on the children who are lingering in care and find them permanent situations. Thank you.
Thank you, ma'am. I appreciate that. Representative Neal, do you have a question for the witness?
Yes, ma'am. Thank you. Thank you, Ms. Chairwoman. So, question, and any one of you can answer this. So, when it comes to the current rehabilitation plans, I guess the timelines for those, what are those what's the time frame currently look like versus, I think in here is 6 months or less for the bill, but what's the current time frame of those rehabilitation plans?
So currently it's just a case-by-case situation. for overall case plans, right? A child enters into care, and that's really dependent upon when services get put into place for parents, and then their active steps to rehabilitation for themselves, actively engaging in those services. Right now, the federal statute of limitations should be, we have what we call a 15 to 22 month, where we're determining what the permanent needs of those children should be, and we're hoping that they reach those goals by 24 months, but that's not always the case.
Okay, and I have a follow-up, Madam.
Yes, ma'am.
So with that, is there a minimum? So say there's, like you made mention of like a parent saying, hey, I can't do this. Say it's been 3 weeks, 6 weeks, and they're like, no, I can't do this. Who determines when it's been long enough to attempt the treatment and it's time to take the child? Like, what does that gray area look like?
So is
I guess,
Rebecca
I guess
on?
I'm coming from the perspective of if you have someone that's like addicted to drugs or what have you, and if they're making that decision out of haste, like, hey, I don't want to deal with the child anymore. It's been 6 weeks. Is that, and if they're not in the right mind to make that decision, who determines when it's time to take the child versus, oh, this person just not, they're not better yet?
I'm going to recognize Chairman Oliver to answer that question.
If I was listening carefully, because I was reading the bill, excuse me, I think it's the judge who makes the determination.
Judicial
obviously,
discretion.
In any case, and what your question relates to me is that the current law, a judge will decide whether there's been a failure for at least 6 months to participate in any court-ordered plan. But this changes the law to say fully comply with any court-ordered plan for a period of 6 months. I can speculate all day about why fully compliance with a plan would not be the appropriate standard, in my view, consistent with the Georgia case law, which is kind of complicated and dense on this area. Madam Chair, may I ask a question?
Yes.
I'm interrupting your question.
No, go ahead.
Procedurally, is this bill eligible for a vote today? And does the chair intend to take a vote on this?
We're not taking a vote on this bill. It's hearing only.
Thank you.
Thank you,
Representative Neal, okay.
Okay.
All right. And online, we have Representative Kendrick. I believe she has a question.
Yes, my question is about lines 87 through 90. We struck out the conviction of a murder or murder in the second degree, and it seems like we've lowered the standard from the normal criminal standard of beyond a reasonable doubt down to clear and convincing evidence, which is still above preponderance of the evidence, but still lower than the general rule against for beyond a reasonable doubt. So I'm just wondering, what is the reasoning behind lowering the standard and not keeping it at beyond a reasonable doubt, which is usually how it is in criminal matters? As a matter of fact, I've only seen clear and convincing evidence, I think, in more civil trials, and it seems to be more criminal. So can somebody answer what was the reasoning behind lowering the standard?
So we, sorry.
Okay. I was just going to recognize you to answer the question. So Ms. Shimpo or Representative Wiedauer, either or.
So with the clear and convincing standard, what's happening in our courts currently is that we're having to wait years for a conviction in criminal court, and this allows the juvenile court to use their standard of evidence in order to make a decision on a child's permanency.
Okay. Representative Kendrick, does that answer your question?
Can I ask a follow-up quick question just for clarification? So in the juvenile code right now, you're saying that the standard used by juvenile courts is clear and convincing evidence?
Is that
correct? That's
okay.
correct.
Thank you.
Okay. All right. Thank you, Representative Kendrick. Representative Thomas.
Thank you, Chairwoman. So I have a question on lines 113 down. So really it's 117, but it starts from 113. So just to be clear, if subsection A, which we've talked about, the felonies that they have there, are committed, you're saying that it would take, so DFACS is not going to, it would take DFACS's part away where they're going to try to reunify the child with the parent. It takes them out of that and just automatically says if any of the things from subsection A occur, right, then it's involuntary. Parental rights are taken, correct? Yes.
Representative Wiedauer,
It's-
if you'd like
it's
to
a
answer the
trigger.
question.
It's a trigger. If any of those things are met, that could be possible.
Okay, so then the question I have is, it says clear, and on 117 it says clear and concising evidence that any of the circumstances have happened, but that's a conviction though, correct? Wouldn't that be a conviction?
Representative Wiedauer, if you could hold that.
Yeah, sorry, I keep doing
We've
that.
got people on the Zoom that are, we
I
can't
gotcha.
hear, so I do apologize. If you could answer Representative Thomas's question.
Yeah.
Let me know if I'm confusing or
No,
not.
you're on 117, correct?
Yes,
I just
I'm
wanna
on
make sure
117. So the question is this: if these things from subsection A, right, 95, 90 through 99, all these, if these things have occurred, right, in my mind, it's a felony. It's already, they're convicted, right? But on lines 117, it's saying if it has clear and concising evidence. So I guess I'm just a little confused if it's already a felony.
Okay, and that's
what that is.
and I think that goes back to Representative Kendrick's question of like lowering the bar. It is because of the conviction taking as long as it is. If a court finds, so you're talking about parallel cases, right?
Okay.
You've got a criminal case and then you have the permanency cases or these. So if this court case finds that what's going on in the criminal case is clear and convincing evidence that some of these things have occurred, they can, for lack of better terminology, err on the side of caution of this is a aggravated circumstance. It is likely it's lingering in a criminal case, but they can utilize that to place that child permanently for the betterment of that child.
Yeah, I guess what I was just trying to clear it up because, I mean, not saying I'm going to offer a sub, but I'm just trying to be clear because that would be a conviction is what I'm saying. You get what I'm saying? Like, so you're saying because if you have clear and concise evidence, in order to prove clear and concise evidence, then that's a conviction. But you're saying that it would be before they're convicted, that they would have, like if they had a parallel case where they were trying to terminate the child's parents' parental rights, right? You're saying while the case is still going on in court, they would terminate that. You get what I mean? I guess why I'm confused is because if it's clear and concise evidence, then that means that it's a conviction. So I don't know how we like go in between the two if a case is still going on. Or are you saying that they would have to have the felony in order for it to be involuntary?
I would agree with your statement that the way that it is written it is clear and convincing evidence, and I think that's what part of what we're trying to address, and we'd love to talk offline if you want more of that, but is not letting these children linger while that case plays out when it is abundantly clear where that case is headed.
Got it. So the only thing that I would say is that to maybe make it, I mean, how I would say make it better is because it's hard to say clear and concise evidence, or if you're saying maybe it could be something like if they have a case against them, because it's just confusing. I'm just saying, but if they have a case against them that has anything from subsection A, then we would try to move the process along more expediently, is what I was thinking, because you might get confused, that might be confusing, and Representative Mary Margaret Oliver, maybe you can help me out on this one, but I was just trying to say, like, how can we say clear and convincing evidence if it's not a conviction? You get what I'm saying? It's like innocent until proven guilty. I'm on your side, though, because I don't believe that if there's any of these cases that a child should not be able to get a good home, just like your counterpart right here is representing a good home. And thank you so much for all you do for the children. But I just kind of wanted to make sure that we didn't get hung up on that little part if it was something that we can change to kind of get from questions being asked. So I guess it's just a little confusing to me.
Okay. Representative Wiedauer, do you have anything?
I think I would defer. I think Jennifer would love to.
Okay, all right. I'll let you respond briefly since you're not the author of the bill. But the majority of the questions should be directed at the author. Ms.
So
Shimpo.
I was just going to point out that aggravated circumstances is already in federal law. So it's already the subsection A is referring back to that list of aggravated circumstances. So that's already a list in federal law that says if these egregious crimes have been committed against a child, then we don't have to offer services to that parent. The judge has oversight to say, we don't need to work towards this. It absolutely keeps the parents' rights intact because they still have the right to go to Salvation Army, for instance, and get their own free rehabilitation for substance abuses. And so it keeps those rights intact. It just provides judicial oversight to say, in these situations, Georgia is coming into compliance under federal law.
Thank you.
Okay, all right, thank you. Chairman Oliver, do you still have a question? No, okay. And Vice Chair, do you have a question?
Thank you, Madam Chair. Yes, my question kind of goes back to the question about the clear and convincing evidence. I guess kind of just from the standpoint of this person's parental rights are being revoked and they haven't been convicted yet. I guess that was kind of the stipulation, because you're innocent until proven guilty, I guess, is the question. I know it's not, you're saying that federal compliance is a little different than this, but until they've been convicted of a crime, I understand removing a child from a home. I mean, I've worked voluntarily with DFACS for years, and certainly a child should be removed from a home if there's any possibility that any harm is coming their way. But I guess terminating parental rights when someone hasn't been convicted of said crime, I guess is the concern with me with this bill. Has there, based on some of the questions that have been asked today, is there any way we might be able to amend this where it sits a little better with folks?
Yeah, Representative Camp, thank you for the question, and Representative Thomas, appreciate it as always. That's definitely something we'll look at the wording on that and make sure that we tweak that to make this better.
Thank you.
Okay, all right, thank you. Is anybody signed up to speak on the bill?
No, I don't think on this one we do.
Okay, all right. Having nobody from the audience sign up to speak on the bill, would anybody like to speak on the bill? From those, okay. Well, this was a hearing only. I think we kind of got halfway. I think some of the members have some concerns and questions, and I'm sure they look forward to working with you and working through those issues. Representative Wiedauer. Is Representative Lewis Ward here? Representative? I'll recognize you to present your bill. Come forward. You can sit anywhere. There's a microphone. You can come to the podium if you want. You can sit at a chair. Just push the button so I know which mic to make live so everybody can see and hear you. And all right. And again, this is hearing only. Guardian and ward's right to communicate. And Representative, I recognize you to present your bill.
Thank you, Madam Chair, and thank you to the committee members for allowing me to present House Bill 1185, LC 480449. It is a simple one-page bill with no cost to the state, and it provides for a ward under guardianship to have the right to communicate with a family member if they choose to. That's it. It's very simple, and I'll yield for any questions. And how this came to me, Madam Chair, is that a constituent in the district was trying to communicate with a family member, and the spouse would not let them communicate with the family member. And that person is here today to provide testimony to this bill.
Okay, all right. So I think you have a question from Representative Thomas. Is that correct, Representative Thomas? I recognize you for a question for the author.
Thank you so much, Mrs. Chairman. Woman, I guess this is a question that I had and I think that I maybe have asked you this question before. Is there an age limit on this? I mean, is there an age preference in the bill for, I mean, because we're in juvenile justice, so I was just wondering, is this for everyone, you know, or is this for juveniles?
The constituent that came to me was talking about an adult. I am not sure why it was assigned to this committee.
I do think it's a good bill, though.
Okay, all right, thank you very much, Representative Thomas. Representative Kendrick on Zoom has a question.
Thank you, Madam Chair. I'm trying to wrap my head around what the current state of the law is, because I can't imagine if somebody wants to talk to a family member, what is preventing them in current law from doing that? Can you shed some insight on either anecdotally or through statute, what is preventing the ward in your case, Representative, from speaking to that family member?
The current law is silent to whether or not the guardian can or cannot prevent a family member. And so because it has been silent, they have been taking advantage of the silence in the law not mentioning anything about being able to communicate or having that right, and kind of isolating the ward from family members if they choose to.
Okay, does that answer your question, Representative Kendrick?
Yes, thank you.
Okay, thank you, Representative. I'll recognize Chair Oliver.
I was talking with Legislative Counsel about whether this particular code section applies to children and adults both, because there's guardianships of children, there's guardianships of adults, and they're different in the statute. The fact situation you brought is for an adult, and I like the bill for that purpose. A guardian appointed by the court has total power over that person. And sometimes based on family frictions or family bad facts, a guardian will prevent a ward from having relationships with other members of the family.
Mm-hmm.
That seems onerous to me, and in my experience of having this fact situation, I've seen it onerous. There are possibly good reasons that you would want a ward not to have contact with a problematical family member, but I think the judge could decide that if it really was a toxic relationship. So I like the bill for the purposes of adults. I'm thinking through whether it would be appropriate in some cases for a guardian of a child, say a grandparent, to not allow that 6-year-old child to speak to some other relative. That's a little bit of a different situation.
Mm-hmm.
But I like the bill. I think it applies most pragmatically to adult wards.
Okay, all right. Thank you, Chair Oliver. Vice Chair Camp.
Thank you very much, Madam Chair. I like this bill too, simply because I know in our communities we do have people who are wards, and for various reasons, sometimes isolating them, they are abused and do not have means to communicate that situation with others because of the isolation. And I know those are very seldom events, but certainly people being able to have contact with others is important. So thank you for bringing this bill.
Thank you very much, Vice Chair. Representative Neal, did you have your question answered? Okay, all right, thank you. Thank you very much. The Chair would, this is a hearing only, and I have learned the hard way that unless you put some teeth into something, it won't work. So I would very strongly encourage you to keep efforting this bill and maybe put some teeth into it, that you'll be in contempt of court, or something will happen, you know, you'll get shot by lightning, or, you know, some sort of penalty, or some sort of, there will be a consequence to the guardian for forbidding that communication with that ward. And for that reason, I would certainly encourage you to keep working on that. Representative Thomas, you have a comment?
Well, thank you. I think you answered the rest of it. I was just going to ask if we could, with the chair's discretion, maybe do a substitute to add to that part into the bill.
If Representative, if the author of the bill would like to continue working on it and we can get it through before the end, then I'm very content to keep working with you on the effort. But like I said, it has to have some sort of consequence, or some teeth or something like that for it to work. I've passed a lot of bills that didn't have anything and no consequence on the back end, and people just ignored it, much to my consternation.
Absolutely, and thank you very much for offering that.
Okay.
I would definitely like to continue to work so we can get it through.
Thank you.
If it's your will, Ms. Stewart is here to testify.
I'm sorry. Oh, you have someone here to testify. I do apologize. Ma'am, if you'd like to come forward. If you'll just sit anywhere there's a microphone, and we can see you, that's fine. So, right. If you'll hit the button, the request to speak. Okay. All right. Thank you, ma'am. Introduce yourself to the committee and whatever comments you'd like to make on the House Bill 1185.
Yes. Good afternoon, committee members. My name is Ethan Stewart.
Ma'am, I
Yes.
do apologize. You're going to have to hold that microphone a lot closer. We
Okay,
do have a
thank
number
you.
of committee members that are on Zoom,
Okay.
and they will start blowing my phone up saying, we can't hear. So,
Okay, thank you. Thank you.
make sure you hold that microphone really close so it can
Oh.
go over the web as well. So
Thank
thank you.
Thank you. Good afternoon, committee members. My name is Ethan Stewart. Thank you for the opportunity allowing me to speak on behalf of my brother, George L. Burgess Sr., who is 79 years old, who is suffering from Alzheimer's, and who is a ward under a conservatorship. I hope my testimony today can bring awareness to this issue and help others who's in similar situations. It has been a year since his health has declined. His wife is a conservator and cut off all line of communication between him, my siblings, and I. Here are a few examples of how this affected our family. Until my communication was cut off from my brother, he and I had spoken daily. One day, he confided in me that he was in pain. I spoke with his wife concerning this, and she responded, I'm not taking him back to the doctor. I have taken him to the doctor before, and I'm not taking him back again. Soon after that conversation with his wife, she did not allow me any more communication with him. In an effort to see him after being cut off from him entirely, I decided to do wellness checks on him. During one of his wellness checks, the officer who accompanied me told me that he was going to go in and speak with my brother's wife after he witnessed that she would not allow me to see him. The officer asked my brother to come out, and he came out on his walker, and we embraced, and I cried. The only way I could see my brother was through wellness checks. When he was no longer able to use his walker due to his declining physical state, he was no longer able to walk out of his home, and I was no longer able to see him. It has been almost a year since I've been able to see my brother. Please vote favorably for Bill 1185. Thank you for listening to my story, and please join other states who have actually passed this law on conservatorship and allowing family members to see their family. I thank you so very much.
Thank you, madam. I know it takes a lot of courage sometimes to come up here and testify. We can be kind of an imposing or intimidating venue, but I applaud your fortitude in representing both yourself and your brother. I think that he is very lucky to have such a sister that would stand up for him like that.
Thank you.
Members of the committee, any more questions of the author or the witness? Seeing none, we'll conclude that hearing, and I will call House Bill 403. Again, this is for hearing only. Representative Wiedauer.
Thank you, Madam Chair. Bringing you House Bill 403 LC 480571S. This is a department bill for the Office of Child Advocate. What this does, and I believe the director's here, and he'll be speaking to this as well if the committee chair lady will allow. What this does is often, this is to ensure quality representation in court hearings. A lot of times these cases get assigned to quality representation that hasn't had proper training, and some of these cases kind of fall through the cracks. This would implement statewide measures and standards and responsibilities for attorneys representing parents and children. That is basically what the bill does, and I know the director's here and would like to speak to it as well.
Oh, okay. Mr. Bruce, would you like to step up? You can, like I said, just anywhere there's a mic. Go ahead, if you'll introduce yourself to the committee.
Thank you, Madam Chair. My name is Jerry Bruce, and I'm the director of the Office of the Child Advocate in Georgia, and we have wide-ranging responsibilities. One of our responsibilities deals directly with the quality of certain types of representation in our juvenile court dependency and termination of parental rights cases. We currently have the responsibility to do pre-appointment certification for guardians ad litem who are practicing in our juvenile courts. And now, there's two things going on at once, Madam Chair. The first is that the most common complaint we have from juvenile court judges, from other people who participate in our juvenile court system, is that there is a real lack of quality legal representation in our juvenile courts. Our 2014 Juvenile Code really elevated the status and professionalism and, in many sense, the technical difficulty of practicing in juvenile court, and we've not really had a push to elevate the standards for practice in the courts to rise to the level of the raising the bar that happened in our 2014 Juvenile Code. At the same time, because the training of attorneys and the payment of attorneys is generally something that has fallen to the counties in Georgia to pay. Most counties in Georgia deal with hourly appointed attorneys on a contract basis, and those folks are paid out of county funds. Counties are paying for attorneys, and we're hearing some county commissioners raise complaints that they're paying for perhaps inadequate representation in some cases. A couple of years ago, the federal government changed the rules for reimbursement by states under the Title 4E of the Social Security Act. As you probably already know, Madam Chair and members of the committee, Georgia receives a lot of money every year in reimbursements from the federal government for complying with federal requirements in a large array of measures dealing with our child welfare system. For the first time now, the state can receive reimbursements for the cost of quality legal representation as well. That used to never be the case. One of the standards is, one of the requirements is that it not just be the perpetuation and continuation of legal representation as it has been, but that there be a real push to coordinate, to provide training up front for attorneys practicing in juvenile court, ongoing observation and accountability for those attorneys practicing in juvenile court, professionalism and standards put in place for them as well, so that we're raising the bar, so that the federal government is paying for an improvement rather than a continuation of status quo. So this bill asks for the ability to put all of those things under the heading of the Office of the Child Advocate. It's sort of within our wheelhouse to help improve outcomes. We find that many of the types of outcomes that seek to be addressed in other types of legislation, like for instance the Aggravated Circumstances Bill from which Madam Chair and the committee members have just heard, those types of outcomes are directly affected by the quality of legal advocacy in those courts. Many of the measures sought to be addressed by putting in new laws into effect can actually be addressed by providing more quality legal representation up front. So that's what we're asking for in this bill, and I'd be happy to answer any questions from Madam Chair or any members of the committee.
Okay. Members of the committee, do you have any questions? Anyone online? Okay. Seeing no questions, the hearing is concluded. Thank you. I do appreciate it.
Thank you.
And with that, our agenda is exhausted, and we are adjourned.